Good morning. My name is Bill Herbert. I'm the Executive Director of the National Center for the Study of Collective Bargaining in Higher Education and the Professions at Hunter College. Welcome to Roosevelt House, where this is the former home of Franklin Delano Roosevelt and Franklin's mother, Sarah. In the early 20th century, Sarah Roosevelt bought these two mansions had built for two mansions for her and her son and daughter-in-law. They lived here till 1941. This is the New York City address, and then they sold it to Hunter College. It has a lot of history here. A lot of history took place here, including prior to his inauguration, FDR meeting with Francis Perkins and committing to supporting Social Security and child labor laws, prohibiting child labor laws, and a bunch of other things that became the basis for the New Deal. So today's panel this morning, thank you for coming, is a panel that was co-organized by the Association of Labor Relations Agencies. And that's a national organization of labor relations agencies that both in the public and private sector and from the US and Canada. And one of the things we've done this year in our conference has been getting co-sponsorships from organizations. So on Sunday we had a panel that was co-sponsored by the National Association of Arbitrators, National Academy of Arbitrators, and we've had another Title IX panel with the National Academy of Sciences. Last night we had here and this is the diversity of our programming, we had a panel that was co-sponsored by the Music Workers Alliance, and we had a performance by Mark Ribot, the internationally renowned guitarist, and then a discussion about labor relations issues involving music workers. So we're very, very pleased with that, and many of these panels are going to be videotaped, or have been videotaped, and we'll have them online as soon as we restore our sanity after completing this 3-day conference. Just one of the things that is important to recognize is that labor law has had a substantial impact, in many ways more of an impact on higher ed than other industries, and really faculty unionization did not really start to happen until after laws were enacted in New York and other states, and the NLRB granting exerting jurisdiction in 1970. So there's a direct interrelationship between higher ed and labor law, and labor law is interpreted by labor relations agencies. Now, our national center actually has a long and glorious relationship with New York State PIRB, which is represented here by its chairperson, John Uranus. New York State PIRB issued its decision in 1968 involving CUNY faculty, and that decision then led to the first collective bargaining agreements in CUNY for faculty in 1969. As a result of that successful negotiations, CUNY created and organized a national conference on collective negotiations involving faculty on May 1st of 1970 at, ironically, the Waldorf Astoria. And at that session was a law professor named Donald Wallet proposed that some university create a center to study collective bargaining in higher education, which then wound up being done by CUNY in 1972. And since 1972, New York State PIRB and National Center have been involved in a variety of ways. The first actual training ever conducted by the National Center was done in conjunction with PIRB in 1972, and every PIRB chair has been either on our board of advisors or has been a presenter at our conferences, along with, I think, every deputy chair, except for one, has been involved with the National Center. And before I came to the National Center, I was deputy chair at New York State PIRB. So we're very, very happy to have a panel of these agencies which all issue decisions regarding higher ed, which the panelists will be discussing. And if you are subscribers to our newsletter, we report on a monthly basis decisions and certifications and petitions that are pending at these agencies. And one of the reasons we're able to do that is that many of these agencies have electronic resources for us to do our research. So we're very thankful for the agencies, and we're very thankful to Mike Sellers, he's the Executive Director of Washington Public Employee Relations Commission, and Mike is going to be moderating this panel and introducing our panelists. Thank you, Mike.
Good morning, and welcome everyone. As Bill said, I'm Mike Sellers. I'm the Executive Director of the Washington State Public Employment Relations Commission, and also the current president of ALRA, the Association of Labor Relations Agencies. So, you know, being labor relations professionals, we're going to have a pretty loose format today. That's what you should come to expect from us. And we're going to have the folks I'm going to introduce here in a minute talk about the various the issues and kind of background on their state with respect to higher ed, and I'll kind of weave in and out as it works. And of course, if there's opportunity for questions, I didn't ask them beforehand, but I think we'd all be in favor of it. We've all heard ourselves talk plenty, so we do like to get questions. In addition to myself up here today, we have John Wernius, the chair of the New York PERB, as Bill mentioned. We also have Mary Beth Schotter with the New Jersey PERC, and Marjorie Whitner with the Commonwealth Employment Relations Board in Massachusetts. Marjorie's the chair of the board, and Mary Beth is, I think, the director of conciliation. Yeah. On the West Coast, we call it mediation. On the East Coast in Canada, they call it conciliation. So I think Marjorie mentioned going, or Mary Beth mentioned going first, so that became, she claimed it.
Okay. So this is on, yes. I'm going to try to work this. I talk with my hands. I'm from New Jersey, so, you know, I have 3 things I have to do here, but we'll get it going. All right. Okay, so when I met with our staff at New Jersey PERC to talk about 50 years of higher ed unionization in New Jersey, we realized we've been pretty lucky. We haven't had a lot of high-profile cases. Until maybe next week or the week after. We'll see. We'll get into that in a minute. So what we wanted to talk about, what's been happening a lot in New Jersey, is we've had a lot of statutory changes to our act, especially in the last 2 years, that have affected higher ed units. So I'm going to go through that and work in a little history and some cases, okay, in a very short period of time, and hopefully I can yield some time to my colleagues on the panel. So New Jersey PERC was created by the legislature in 1968 following a series of concerted actions in mainly public school districts in the late 60s. It created the Public Employment Relations Commission. We are a neutral agency in but not of the New Jersey Department of Labor. We have a tripartite commission, 3 public members. Our current chair is Joel Weisblatt, who some of you may be familiar with. He is also a grievance arbitrator in other states. And it's worth mentioning that our longest serving member is Professor Paula Voos from Rutgers. And Paula has been hanging on as a member of the commission. I think her term expired in 2012. So we're very grateful for her holdover status and that she keeps driving to Trenton from New Brunswick once a month to come to our meetings. We also have 2 labor members, 2 management members. We're currently have vacancies in one of those, which disappoints us, and we hope to soon the legislature can act and approve members for us. We have 3 sections: general counsel, unfair practices and representation, and conciliation and arbitration. And when obviously the act did other things than just create PERC, but when the act was issued, it was based on the National Labor Relations Act, but it was silent on whether or not public employees in New Jersey could strike. We did not have to, and I say we, I wasn't even alive, but we did not have to wait long. It was within a year that we had a strike in Union Beach Board of Ed, and the New Jersey Supreme Court in Union Beach Board of Ed held that in the absence of an express statutory grant, public sector strikes were illegal in New Jersey. That's not to say we haven't had some. In March of 1979, the state college faculty had a strike that lasted several days. And in the late 1970s, there was an administrative unit at Brookdale Community College who also had a strike that lasted about a week. We've gone 44 years in New Jersey without a strike in higher ed. Most of you are probably aware that the Rutgers AAUP and part-time lecturers have authorized a strike vote. I'll be looking at my phone as soon as I get off this dais. We're day to day, we are monitoring it, and will be involved as necessary. So in order to talk about the statutory changes, I just want to really quickly go over how higher ed is organized in New Jersey. So we have two major public research institutions. If you work at one of the state colleges in New Jersey, I know that you're now considered a research institution as well. However, this is how it came to be. We have Rutgers and NJIT. Their labor relations are handled in-house. They have a board of governors, they have a president, and they have general counsel. They have numerous negotiations units. I may just start hitting John to hit the button. So we also have nine New Jersey state colleges in New Jersey. They are part of the executive branch of the state government. Their labor relations are handled by the governor's office. Like I said, if you remember from the last slide, 2 slides ago, there was a strike involving all of these employees in the late 70s. The number of executive branch units in New Jersey is capped by statute. So we're only allowed to have 10 executive branch bargaining units in New Jersey. So these are represented by the Council of New Jersey State College Locals, AFT, and the adjunct unit. They're described in our statute as state college and university unit and state college and university adjuncts. They do have other employees who aren't faculty, and they fall into the 8 other units. So we have broad-based units in New Jersey. So you could be a doctor at one of our psychiatric hospitals and a landscaper at one of our state colleges. You're in the same unit, okay? The next group is the community colleges in New Jersey. We have 19. Anybody from New Jersey? We have 21 counties. We do have some consolidation. They are run by county commissioners, and their labor relations are handled by the college administrators with the oversight of the county commissioners. There's a lot of involvement with PERC in the community college negotiations. It's my least favorite word when I get a case that I have to go into is county in New Jersey, because the Wizard of Oz is calling all the shots, and I don't get to talk to them usually. So, you know, they have more difficult labor relations. They have numerous units. Most of them are an organization related to the NJEA. Okay. Thank you. So coming to our statute and the amendments that affected higher ed. So in 1977, New Jersey amended our act to allow interest arbitration for police and fire employees. For those of you unfamiliar with interest arbitration, it's binding arbitration to reach a successor contract or agreement. So that was 11 years. We waited to get that for our police and fire employees. And then it took 16 years for one of the college police units to file an interest arbitration petition when they reached impasse with Rutgers. So the FOP filed in 1993. Rutgers, as they have a tendency to do sometimes when we get a new statute in New Jersey, moved to dismiss the petition, arguing that the police department was not a municipal police department or an agency of the state, and therefore was not covered by our interest arb statute. The commission, PERC commission, did not agree with that, and certification was eventually denied by the New Jersey Supreme Court. So campus police in New Jersey can avail themselves of interest arbitration for a successor contract. Thank you. Next, we have the New Jersey School Employees Contract Resolution and Equity Act. This amendment to our statute came out of a bunch of teacher strikes that were happening in New Jersey in the late 90s. Jersey City teachers went on strike, the Patterson teachers went on strike, and I think the last straw that caused the legislature to act was in 2001, the Middletown teachers went on strike. And in Middletown, the Board of Ed did move for an injunction. I was talking to Marjorie beforehand, so in Massachusetts, apparently, her agency would get involved with enjoining a strike. We do not. In New Jersey, it goes to the court. We are such a neutral in but not of agency, we won't even get involved in the illegal strike and declaring it illegal. It's for the courts. So in Middletown, this hadn't happened since the 70s, but the teachers were incarcerated. The judge issued the injunction, and if you can imagine, put yourself in Middletown, New Jersey in October of 2001, the town that lost so many people on 9/11. And I don't think there was a public appetite either from the judiciary or the public for this strike at that time. So the teachers were alphabetically brought to court and asked whether they will return to work. And while, in the meantime, obviously, there's major mediation going on between the board and the units. And then they were put in Monmouth County Jail, and it lasted about a week. So that bore out this change to our statute. And this applies to all higher ed as well. It eliminates the ability, well, it eliminated the ability of a Board of Education or a higher ed employer to impose a contract after impasse procedures are exhausted. It also prohibits any changes in the terms of conditions of employment of the unit employees prior to or after contract expiration. It requires mandatory fact-finding after mediation. I'm a mediator, so I don't say fails, is unsuccessful. And it adds super conciliation as a contract resolution method, which includes the ability of the super conciliator to order 24/7 negotiations without having to go to court. They have that ability to order that. They have broad statutory powers. Thank you. Okay, 2009, police and fire again. So this was our big case this year. In 2009, the legislature passed special disciplinary arbitration. In New Jersey, prior to 2009, if you were a campus police officer, you didn't have any right to appeal your termination or major discipline in arbitration because you were not a civil service employee, you were not considered a state employee, you were not a municipal employee, so in New Jersey, municipal employees can go to municipal superior court to challenge their terminations. You were kind of stuck in this donut hole. And there were a lot of cases coming before PERC on scope cases where police officers would file for a grievance arbitration to challenge their termination, and we would have to restrain the arbitration because of a New Jersey Supreme Court case known as State Troopers that says police cannot challenge their discipline in grievance arbitration. So as soon as this law is passed, NJIT challenged in a scope proceeding a case where a NJIT police officer was trying to challenge his termination. PERC said, no, you can't in grievance arb, but we'll let you go to this new special disciplinary arb. Lo and behold, they appeal that. The parties end up settling it. So all we have is this PERC decision in 2009 that says it applies to campus police. Fast forward to 2022, well, actually 2020, I'm working at home, I'm sitting on my bed, my dog's on my lap, and I write a quick decision that says, you know, see NJIT. Yes, this NJIT police officer named Mr. Officer DiGuglielmo can have SDA. Send it off. It didn't even have a caption, it was a letter. Next thing you know, I'm appealed to the appellate division. And a professor of mine from law school writes a decision that says how wrong I was and how we do not have, it doesn't apply to campus police. They appeal, and in November, the New Jersey Supreme Court held that campus police do have the right to challenge their termination through special disciplinary arbitration. And I felt a little smarter and less upset than when I had read that appellate division decision. Okay. I'm going to move quickly through this. In 2012, this was the largest higher ed merger in the United States. Rutgers acquired, I don't want to say acquired, merged with UMDNJ, and Rowan down in South Jersey acquired the UMDNJ School of Osteopathic Medicine. This created a lot of rep work and unfair practices at our agency. We're still dealing with rep issues from what we call the legacy UMDNJ units and where they should be, who's confidential, who's not. Okay. All right. And now to the exciting new stuff. In 2018, in anticipation that the Supreme Court was going to overrule Abood v. Detroit Board of Ed in the Janus v. AFSCME case, the New Jersey legislature passed the Workplace Democracy Enhancement Act. This is the policy statement that they issued that I won't read to you, but it's in your materials. So, like I said, it was passed because they felt that Janus was going to find rep fee payer agreements to be unconstitutional. In what we call the WDEA, it expanded negotiations units in New Jersey. We've had a lot of work, especially at Rutgers, with this because now all full-time and part-time employees can be part of one unit, and the only test is, are they doing unit work? Okay. It also provides access rights to employees. So you can see how this was basically to help unions stay in contact, post-Janus with their membership. The majority representative has to have access to the employer's email, and it has to have access to government buildings to hold union meetings and to meet with employees. It also requires that the union and management negotiate over rules to provide that access, and if they are unable to reach agreement, binding arbitration. All right, next. All right, in 2021, we had a major subcontracting law passed. So here on this first slide, okay, we have to move over one. Okay, here on this first slide, you'll see that it applies to all three higher ed units: county college, state college or university, or public research university. And it provides that all aspects or actions relating to or resulting from an employer's decision to some contract, including but not limited to whether or not severance pay is provided, is a mandatory subject of negotiations. So it prohibits employers from entering into subcontracting agreements if affecting a negotiations unit. And how this is bearing out is 90 days prior to a decision to subcontract, an employer has to file a notice with me, copy it to the union, put them on notice, identify the parties, the individual positions that are going to be affected, and give the union an opportunity to try to negotiate a way to save those jobs. In practical terms, that's what happens. It also provides that displaced employees have recall rights and seniority rights, and it requires those negotiations, which was not happening before. If this is not followed, it provides for an unfair practice that can be filed, and a rare instance in our act, it's only the second place in our act where fee shifting, if you file and are successful on an unfair practice charge, the other party will have to pay your attorney's fees. So that's something new for us. It's only happened in the last few years, fee shifting's being written into our act, but it's there. It's helping us settle these cases, because once we tell the other side about the fee shifting, they normally, sit down and work out a deal. Next page. Okay, thank you. So finally, this brings us to the big change we've had in 2022, which is known as the Responsible Collective Negotiations Act. This is post-Janus legislation. It's also an opportunity to protect public sector unionization in New Jersey. When first introduced, there was a comprehensive bill that applied to almost all public employees in New Jersey. I'm only going to go through highlights of this. It's on our website if you really want to dive in. I wouldn't have enough time to talk about each part of it. But after it was introduced, lobbying efforts were brought about, and higher ed was cut out of good portions of this law. So I'm going to start with the portion that higher ed was not eliminated from, and then I'll tell you what higher ed was eliminated from. So the parts of the law that apply are unions may require non-members to pay for the cost of arbitration. Okay, so if you have former fee payers who are now just non-members and they want to file a grievance, you can require them to pay the cost if you're on the union side. Only unions and employers can invoke the arbitration provisions of a contract. So I'm seeing this play out with some, not higher ed, but state units where we have those Big 10 broad-based units, and in them we have like little associations in New Jersey. And in the past, the state used to process grievances from these locals, and now they're objecting. You know, if the full IFD unit has not filed for it, I cannot process a grievance to arbitration that's not filed by the majority rep. Okay. It permits the use of electronic signatures on authorization cards. That's new. Someday New Jersey PERC will have a computer system, hopefully, that can handle such things. We're working on it. And it provides for expedited processing of unfair practice charges. This is the first time the legislature has put time limits on us as far as deciding cases. So for what we would call an A3, which is a retaliation charge, we have to issue a complaint within 60 days of filing, and we have to have a hearing scheduled within 120 days from that complaint being issued. And then lastly, we had an appellate division decision about 10 years ago that was kind of wonky in New Jersey that said that only PERC could enforce its orders in Superior Court. And it was kind of sitting out there, and this law changed that any party may take one of our orders and enforce it in Superior Court. All right. So next is some things that higher ed was excluded from. So higher ed, and you're in company with counties. There was a permissive category of negotiations. So there's mandatory subjects, right? We had created permissive, only police and fire had it. Now other employees have it, but it was carved out for higher ed. So there is not a permissive category of negotiations for higher ed. A limitation of regulations that preempt negotiations. So we do have some regulations that provide for sick time minimums and things like that. We've also had some regulations, which I think this was more geared towards, that allowed for furloughs in New Jersey. This limits, not to higher ed, but to other employees, that those regulations only pass prior to this law would apply. So any new, so basically the executive branch couldn't start without negotiations, imposing contract terms through regulations, like we've seen happen in New Jersey a few times. And then resolution of all contract disputes through binding arbitration. So that higher ed was also excluded from that. I don't know why. I don't get into how the sausage is made, but that's what happened. And finally, I just want to end with some cases that of note to watch in New Jersey, besides what's going to happen at Rutgers. So this is a masking case in Rutgers. The majority of the faculty unions in Rutgers filed for an injunction when Rutgers eliminated the mask mandate. And a TRO was issued by one of our commission designees. And then when he heard argument on the case, the TRO was dissolved, but he had ordered a process where Rutgers and the unions would identify those individuals who are most vulnerable to the virus, and ordered them to work out a process to have those classrooms masked or those sections of the library masked. That order was appealed to the PERC Commission, the full commission, and they dissolved it. So they let the status quo stand, which was that Rutgers lift the mask mandate. The unions quickly went to the appellate division to try to overturn that, and their motion was denied. So right now, this case is going through the normal course, and I don't know what's going to happen after the hearing, but whether or not the Rutgers could eliminate the mask mandate without negotiations is the question that will be answered in that hearing. And then next is open bargaining. This is a hot topic. As a mediator, I'll be honest, I don't love it. I don't love it in mediation. I have no problem saying that. But, when you're having your bilateral negotiations, do what you want. This is dueling unfair practice charges filed by the Watchung Hills Board of Ed and the Watchung Hills Ed Association. The union wants to have the entire unit there for negotiations. The board proposed a ground rule that they would only have their negotiations team. They've both filed unfair practice charges against them. A complaint has been issued and it's going to hearing. This will be a case of first impression. For us, we had another one, but open bargaining was kind of put on hold due to the pandemic, but it's back, so we'll see. That's all I have on statutory changes in New Jersey.
Thank you, Mary. Did I go over? Nope. Yeah, you're good. Thank you, Mary Beth. You mentioned open bargaining in Washington State. We've had those issues as well. Our commission has rolled on them a couple times. Similar dueling unfair labor practices. It's an unfair labor practice to condition bargaining on a permissive subject, as our commission and the courts have found. And when both parties say, I'll only do it in open or I'll only do it closed, they're both committing an unfair labor practice. The quandary, of course, then is what's the remedy? Well, the remedy is go back and bargain, but how do you go back and bargain? And our commission struggled with that. They conceived a remedy of, well, go back and bargain. If you can't agree, mediate. If you can't then agree, you'll just default to the way you used to have done it, which of course would have been closed bargaining. The courts of appeal said, well, you've gone too far in your remedy. Go back and fashion a new remedy in it. They went back with, go back and bargain, don't condition it on a permissive subject to bargaining. And then ultimately we had that similar issue where different jurisdiction imposed ordinance that required open bargaining. That went straight to court. The parties filed a lawsuit in court, and our Supreme Court just recently in the last year ruled that those communities that have passed ordinances have violated and usurped the authority for bargaining, and you cannot condition it through ordinance or anything in that respect. So kind of started, I think, laid the groundwork and said, and ended, I think, the question about whether you can impose open bargaining. Of course, parties may ultimately agree to do it, and we certainly see in the higher ed sector in Washington with the kind of the quasi, the grad students, the TAs, the postdocs, et cetera, they tend to bargain in an open manner with the entire bargaining unit being there. So I just kind of want to touch on some of the points that Mary Beth mentioned. And I'm going to turn it over, I think, to Marjorie now, and we'll take us up to Massachusetts for a nice tour before we come back to New York with John.
Sure. Before I start, open bargaining has also been an issue in Massachusetts. It became more prevalent after Janus was issued, and the guiding principle from the MTA was we need to show our members what we do for them in order for them to understand why we're charging them dues. It met with resistance almost immediately, and what the MTA did in response to the notion that this is a permissive subject of bargaining was it designated the individuals who were not part of the primary bargaining team as silent observers. And they said, hey, they're part of our bargaining team, and you, employer, you have no right to decide who you're going to bargain with. And that works up to a point, but there's also decisions coming out of Massachusetts for years that says, well, you also, as a bargainer, can't make bargaining conditions completely non-conducive to bargaining. In other words, having 50 rowdy people in the background. So the SERB's decisions on this issue have tried to draw a compromise, the tension between those two principles. But anyway, I digress. I'm Marjorie Whitner. I am delighted to be back here in person, back here in New York where I grew up, and back here with my ALRA colleagues. As usual, if any of you have heard me speak before, I have an overly ambitious agenda, and I'll try to make short work of it, but I'm not going to make any promises. In keeping with the 50th anniversary theme of this, I'm going to, well, first I'm going to talk a little bit about my agency and the history of public sector bargaining in Massachusetts. Then I'll go over the history of collective bargaining among faculty and students in higher education in Massachusetts. That also goes back almost 50 years. Then I'm going to touch on one case which is not so new, but is still very interesting. It's a mandatory subjective bargaining case that arose out of the tension between bargaining with faculty and the argument that doing so intrudes on managerial rights and prerogatives to make educational policy. Finally, I'll bring it up to the 21st century, which some post-Janus developments, which you'll see are similar to those that Mary Beth just talked about, and a couple of cases that have come out recently in response to challenges on the constitutionality of the doctrine of exclusive representation. So, quick overview of public sector higher education in Massachusetts. Full collective bargaining rights were granted to all public sector, almost all public sector employees in Massachusetts. Our statute looks very much like the National Labor Relations Act, except we include supervisors. We don't exclude them, but we do our very best to keep them out of the same unit with the individuals whom they supervise. It is illegal for any public employees to strike in Massachusetts, but as in New Jersey, that doesn't mean that they don't do so. And leading up to this, I was fully expecting 3 teacher strikes in one weekend. Happily, one has settled, one is, and 2 are on hold and to be continued. So it's been a very busy fall and winter for us. As Mary Beth said, our agency is the one, if an employer believes that a strike is going to occur or is occurring, they come to our agency, my board, which then conducts a very quick investigation to determine whether or not it is in fact a strike that's unlawful. If it is, we issue an order saying, please don't do that, although we don't say please necessarily. If they continue to defy it, then our chief counsel goes into court to get a temporary restraining order or an injunction. If they continue to violate, we go in for contempt. So it's not only been a busy fall for me dealing with 4 actual teachers' strikes, but for my chief counsel and for our mediators, who, shout out to them, have managed to settle most of those strikes. We do not have any binding interest arbitration, except as in New Jersey for fire and police, but it's only municipal fire and police. So we've never had a case involving the police units that are in public education in Massachusetts go forward. Like the NLRB, we handle representation, unfair labor practice cases. We have hearing officers who conduct investigations to see if there's probable cause. If there is, there's a complaint, it goes to hearing, they issue a decision. My board that I chair, the Commonwealth Employment Relations Board, is the appellate body within the Department of Labor Relations. I'm the full-time chair. There are 2 per diems, and we hear both appeals of dismissals of unfair labor practice charges and the hearings themselves. Another role or hat that I wear is I do all the unit clarification petitions, and if you're not familiar with those or use a different word, that's if a new position is created and the employer and the union can't agree on where it might go. I investigate those, sometimes hold a hearing. We have a lot of those coming out in higher ed because higher ed administration is constantly reorganizing itself, and everybody is a manager or everybody is confidential. I've left that completely out of this, and believe me, you'll be grateful that I've done so. Finally, in 2007, we authorized card check, and that is just for new or currently unorganized units. And that's been fine. The sky has not fallen as a result of having card checks. Really quick overview of the Massachusetts public colleges and university system. The University of Massachusetts system is the largest. There are 75,000 students there, and about a fifth of which are graduate students. I have something. There are, let me go back. All told, in the UMass system, there were about 75,000 students. UMass Amherst is the biggest and the oldest. Right now, there are about 28,000 students, about a fifth of which are grad students. Lowell is next, roughly 18,000 students. UMass and Boston were sort of the beginning, and then other universities that had existed in a different format came into the UMass system a little bit later. We also have state colleges and universities. They're a little bit smaller, roughly less than 10,000 students and about 300 faculty. And finally, our community college system. I didn't do what Mary Beth did, which to count the number of counties versus the number of community colleges, but they are nicely, and if you know Massachusetts, they are nicely and geographically distributed around our tiny state. So the bargaining rights for full-time faculty in Massachusetts started almost as soon as the statute was passed, almost 50 years ago. And it developed differently in the community college system versus the state college system versus the UMass system. And the community college system and the state system, though, were pretty much in lockstep with each other. So first, the agency certified the full-time faculty, and then about 10 years later, the MTA affiliate, the Mass Community College Council, which is a mouthful, filed a petition to represent the day and night school faculty, also called the Division of Continuing Education. And the Board of Higher Ed, which is the statutory employer for the community colleges, strenuously objected and said they're not employees within the meaning of Chapter 150E, and even if they were, they're simply too casual. Yesterday during the grad student session, there was a lot of discussion of the problem with churn. And I understand, why the unions might have a problem with that, but as the agency that has to certify what an appropriate unit is, we also have to address that issue to determine whether or not there's a sufficient regularity, a sufficient interest that these employees would have that warrants granting them collective bargaining rights. And finally, the last part of the three-part test that the SERP has used for each of these faculty that are not regular continuing ed faculty and part-time faculty is what unit did they go into? Did they go into the full-time faculty unit, or do we keep them separately? And as it says on the slide, to determine whether or not they're employees, the SERB uses the common law control test, which is a presumption that if in fact you perform services for money, you're going to be an employer, but that's rebuttable by the employer to say, but we don't have control over you. And for the community college faculty, as well as for the part-time faculty, which the MCCC petitioned for just 2 years later, we determined that the employer does in fact have a great deal of control over these employees. Even though their hours are sporadic, they're subject to supervision. They're told what courses that they need to teach. They're often subject to handbooks and evaluations. And as far as the regularity of employment, whether or not they're casual, the SERB also developed, well, it did something interesting. It looked back in the prior 2 years and said, well, how often do these employees actually come back? And for the community colleges continuing ed courses, they looked and saw that 60 to 70% of the Division of Continuing Ed faculty returned for at least 1 or 2 more semesters. So that led the SERB to determine, yeah, they're deserving of collective bargaining rights, and here's the standard. The standard is any individual who has worked 3 consecutive semesters or is working 2 semesters and is in their 3rd semester is going to be eligible to vote in the election. and that's the standard that the SERB developed back in the 80s and has used since the community college faculty, the UMass faculty, for both continuing ed and part-time employees. And that's essentially what this slide on state college faculty says. Oh, and one caveat, also the SERB has consistently put the part-timers, what we may call adjuncts or part-time non-tenure track, put them in with the full-time faculty. That's just what we do. If you're doing the same exact work, just for fewer hours, we're gonna put you in with the unit of full-timers. The Division of Continuing Ed, they said, a little bit too different. They're self-funded. There are too many disparities in terms and conditions of employment. So historically, continuing ed folks have had their own unit. UMass was actually the first, these slides are a little bit out of order, apology, but UMass was the first big decision that the SERB issued back in 1975. The part-timers went in, and the department chairs went in, and the issue there was whether or not they're supervisory. The SERB determined that they weren't. The University of Massachusetts wasn't happy, did not want department chairs in the unit, and actually refused to bargain. And the settlement which was reached was, okay, if in a private election the department chairs decide to elect to be included, we'll include them. Well, in fact, the department chairs voted against being included with full-time faculty. So for 38 years, department chairs stayed out of the unit until in 2014, again, an MTA affiliate filed a petition for an add-on election, and the sole issue was, are they supervisory? And I did that hearing, and we determined that there have been a lot of changes since 1976, and in fact, there was a sufficient indicia of supervisory status that if we included them in the unit, there would be too many conflicts, so they stayed out. The MSP remained undaunted, so at UMass Boston, they filed a petition to represent the department head separately, and they won. Continuing ed at UMass, it's just not worth going into. It's a little more convoluted, but suffice to say that the employers' initial reluctance to recognize the grad students performing who also worked at continuing ed led to a strike petition because the grad students got angry that there wasn't voluntary recognition and refused to turn their grades in on time. But we decided that that wasn't a strike because it was never anything that was enforced. So that was the end of that. But anyway, the grad students are now, who perform continuing ed work, are now part of the grad student union, which is a segue to student bargaining. As early as 1976, the SERB held that just because you're a student working for the same place that you go to school with doesn't mean that you're not entitled to collective bargaining rights, and we adopted a case-by-case approach. And in 1979 was the first petition to represent the grad students, and the SERB actually said, using that case-by-case approach, said no. We think there's way too much overlap between your academics and your terms and conditions of employment, and also as far as the control test goes, really those supervisors don't issue a lot of control for you. And I just had to excerpt that little quote over there because it's one of the snarkiest lines I've ever seen in a SERB decision, which is really saying, really, you're supervising them? I don't think the purveyance of quality education really cannot be your primary concern if that's the level of supervision you're giving them. I try to avoid such snarking, you know, or at least it's in my first draft, but I take it out. Take it out in the second draft. And then for reasons that are unclear to me, I was alive, but I wasn't working for the agency at that point. UMass Amherst voluntarily recognized a grad student union in 1991, but it wasn't until 1994 that UMass Lowell, which has its own bargaining unit, the UAW, who represented the grad students at Amherst, filed a petition to represent the grad students at Lowell, and the SERB revisited its 1979 decision and determined on those three criteria, casual, control, and what unit, and determined that, yes, in fact, they are deserving of collective bargaining rights. And eligibility to be in the unit was coextensive with what the grad students actually did, which was to work either 9 hours a week over 2 semesters or 18 hours in a single semester. And that's been going just fine. In 2002, the SERB certified the first undergraduate union. The UAW, I guess, thought things were going so well that they filed a petition to represent the resident assistants, those poor beleaguered undergraduates who have to deal with roommate problems and noisy parties and all of that. The employer strenuously objected to having them organize, said they are students, and tried to tie it to the fact that they were required to maintain a 2.2 GPA, which elicited snarky laugh from the union, who I guess thought that was just way too low, and that's not an academic standard at all. We elided over that point in our decision. We didn't want to get into that fight. And so we certified that union. Then in 2015, the UAW petitioned to add peer mentors. So these are students who live in the dorms but happily don't have to deal with the drunken roommate. Instead, they are there on site to help with tutoring. And the employer said, aha, see, academics. And we said, no, that's somebody else's academics, not the individual employee's academics. So for the very same reasons, we granted the peer mentors collective bargaining rights. The employer also tried to argue, hey, we're going to make this into a course for credit. And we said, maybe, but that's in the future. So, and the peer mentors have been organized since then. More recently, 2021, UMass in Worcester has a medical school, and with no fuss, no muss, card check, the interns and residents were certified. And then in 2023, we almost had an issue. The UMass Dartmouth, which is the only AFT local that we have in all of Massachusetts higher education in the public sector, filed a petition to represent the research assistants and TAs, and the employer was ready to go forward. And if any of you know Joe Ambash, he was the attorney representing the university, and Joe was the one, or whose firm had argued the undergraduates before me, but also the very famous Brown and NYU cases that the NLRB has been arguing about. So Joe was ready to concede that the RAs and TAs, okay, except the RAs who are receiving a stipend exclusively for their own research. He said these are not individuals who are performing services for the university. Rather, this is just financial aid that we're helping them get through school. So we were gearing up to have a hearing on this, and I was doing my research and reading all the NLRB cases, but it went to a consent election. So that will have to wait for another day or another conference. So I want to talk about one case. Over the years, when employers have argued bargaining over terms and conditions of faculty or students' employment is going to interfere with our managerial prerogatives, we said, you know, no, there are enough safeguards. There's the mandatory permissive dichotomy. You don't have to bargain about it. Essentially, we punted until it came to this case, when we actually had to address it face on. And it was a provision that had been in the state college's collective bargaining agreement. From 1986 to 1989, it had been there for a while. And it basically put a cap on the number of courses in any given department that could be taught by adjuncts. And from 2002 on, the numbers of departments in violation had been increasing to a large degree, in part because Salem State offered an early retirement program, so Salem State felt it had no choice but to hire adjuncts to fill the vacancies by all the full-time faculty that weren't there. So they filed a grievance, the union filed a grievance, and in a really remarkable grievance response, you don't usually see such a mea culpa, we're sorry, we're right, we're going to do better response. That's exactly what the employer did. But that didn't keep them from continuing to violate it. And finally, the union filed an unfair labor practice charge, and the employer defended that charge on grounds that, this is the right slide, on grounds that this interferes with our managerial right, or statutory right, actually, to, among other things, appoint faculty, and that is a statute in the Massachusetts general laws. And a hearing officer disagreed, the SERB affirmed, and the SJC also affirmed and said, you know what, it doesn't interfere with your right to appoint, because the right to appoint applies to particular faculty. And it doesn't interfere with your various managerial rights, because it only comes into effect after you determine what courses you're going to give, after you determine how many students you're going to admit, and if at that point you don't have enough full-time faculty, that's when you hire adjuncts. So it's really a means of implementing your policy decision, which is what is the right ratio between part-time and full-time. Because another argument is that the more part-time staff that there are, the greater the workload is on the full-time. The full-time don't do, the part-time don't do any advising, et cetera. So in any event, we rejected that argument, and it's an interesting decision to read, both the SERB's decision as well as I would recommend the SJC's decision. They were very interested in it, the appeals court. And in case I didn't mention, the SERB's final decisions go into the state appeals court, and the SJC, if they find a case interesting, can just say, hey, this one looks interesting, and take it and decide it in the first instance. I'm doing terrible on time, right? No, I don't know. We've had a number of two unfair labor practice, well, wrong, start back. We had an unfair labor practice filed 2014 pre-Janus by 3 UMass employees who were challenging both the constitutionality of an agency service fee back in the day when you could still do that, but also was challenging the constitutionality of the doctrine of exclusive representation, which is embodied in Section 5 of Chapter 150E. And a hearing officer investigated, and even before hearing, rejected the agency service fee. This is very well-established law, and also as far as the doctrine of exclusive representation, it was unheard of to challenge that. It was just a given, and the hearing officer correctly quoted the SJC as saying, exclusive representation is a basic building block of labor law policy. Of course, they appeal, and this is another case that the SJC reached in and said, hey, this looks interesting. Janus was decided in the interim, so the SJC probably happily said, that's moot. We don't have to decide the constitutionality of agency service fees. Justice Alito already took care of that for us. But in terms of the doctrine of exclusive representation, relying on Knight, the Minnesota Community College cases, much older Supreme Court cases, they said that just because you may not have a right to have any voice as a non-member in your union, that doesn't mean that your constitutional rights are being impinged upon. The National Right to Work, which was representing the plaintiffs in this case, came up with the catchy phrase, which relying on MTA bylaws said, hey, what the MTA is doing, if we're not members, they're not giving us a voice or a vote. We can't decide what proposals the employer is going to make. We have no right to vote on a contract. And the SJC's decision said something that I found very interesting, which was that's not any type of violation, even of the duty of fair representation, because the duty of fair representation goes to the output of collective bargaining, what the contract says, and that's where you can't discriminate. But the input, as a non-member, and as somebody who chose to be a non-member, that's kind of what you get in a majority democracy-based system to do so, and they rejected any arguments that it imposes undue pressure on them, again, relying on the fact that that's how democracy works. So those were the branch decisions, very interesting to read, beautifully written. And then this past year, a professor at UMass Law School at Dartmouth filed a charge directly to challenging in federal court, skipped our agency altogether on constitutional grounds, the doctrine of exclusive representation. And that was spawned by the fact that I think around 2020, the union negotiated a contract that had cutbacks in pay in order to avoid layoffs. And understandably, the professor was angry at having no ability to vote on whether or not his pay could be cut. But it went to the district court and then to the First Circuit Court of Appeals. And the Court of Appeals, following precedent that had already come out of Maine and pre-Janus, another case called D'Agostino, upheld as constitutional the doctrine of exclusive representation, rejected arguments that Janus in any way touched upon that issue, and in fact emphasized that Janus went out of its way to leave that intact as a system of collective bargaining. And by the way, in every single circuit court that's reached this decision has decided it the same way. And each and every time, the Supreme Court has denied certiorari. The Peltz Steel case that's up on the screen, the time has not run out for them to file a petition. So perhaps this will be the one that will go forward. And if it does, I'll be sad because it has my name on it because I was an individually named defendant. But I remain very hopeful that the Supreme Court will continue to reject these decisions of the First Circuit. Finally, I promise, finally, we enacted post-Janus statutes very similar to New Jersey with access issues, almost identical actually to what Mary Beth already spoke about. But we also defined for the first, the legislature also defined for the first time what the doctrine of, what the duty of fair representation covers and does not cover. And they limited it, and I'm actually going to skip here, they limited it to the negotiation and enforcement of the terms of agreements. So, for example, if an employee who's a non-member wants the union to represent them before our agency, no. Or if, as in a recent case, I just had a pro se union member who was having a very contentious meeting with a parent over the way she'd been treating, allegedly, treating a student. She argued that she asked for union representation and the employer actually gave it, saying, we never offered union representation to a teacher meeting, a parent-teacher meeting before. But the union is actually defending the manner in which it represented her, saying, hey, we don't even have to do so. So for now, none of those amendments, except for this one issue, have arisen in any end for labor practice charges, but I'm sure they will at some point. So thank you, and sorry for being so long.
Thanks, Marjorie. Before I turn to John, I just want to touch upon a few points that Marjorie made. I promise you'll get all your time, John. Like Massachusetts, we don't, our statutes, we administer 10 statutes. None of them provide a right to strike. A few of them actually explicitly prohibit it, but we have strikes. Actually, in interesting contrast, Oregon to the south of us, their statutes provide a right to strike for public employees, and Washington has had about 8 times as many strikes over the last 15 years than Oregon has had. So take that what you will, what the statutes say. Washington is more of, I think, a statute-driven state as far as how it's set up compared to these. In the higher ed sector, the grad students have a right to bargain by statute. There's actually a legislation pending now that would expand it to the regional universities and probably will catch some undergrad students. Many similar issues that you've heard. We did actually have a strike in the higher ed sector. The librarians at the University of Washington did a one-day walkout late in last year. Probably the biggest thing we see Not a lot of unfair labor practices, a few mediation cases. The culture of the mediation, particularly with the student employees, is very different than the culture of the mediation in any other sectors we have. They tend to be more, as I mentioned, the entire bargaining unit. Many of the issues around inclusivity and gender and things that are hot button issues in today's society, you see first at the table with those groups. Makes more sense given the difference, the age of those groups, and I think it kind of forecasts what labor relations professionals might be seeing in the future. The other thing that we see in the higher ed sector in Washington, with our University of Washington, the largest university in the state, is kind of a contrast of cultures. It's like many higher education institutions, very decentralized, has all sorts of different, its hands in different pots. But lately, it's been a question of, are you a university with a hospital system, with a medical system, or are you a medical system with a university? Because the answer to that question dictates how the bargaining will go and dictates a lot of things. And I think, I don't think UW's unique in what they're seeing there, but those are issues that we are also seeing at the table. So with that, I'm going to turn it over to John, who will take us home with kind of go to the very beginning with New York and the New York PERB.
Well, thank you very much, Mike. I'm very glad to be here. It's terrific to be at the National Center again. I first spoke here as deputy chair, so the rule of almost all our deputy chairs participate. I was one of them. I want to do something a little different than I had originally planned, so good luck. Improvisation always works. I'm going to start covering a tiny bit of the Janus-related material that both Mary Beth and Marjorie have addressed, because we too, and I say we, but it's actually our state legislature, put a panoply of proactive efforts to sort of thwart or limit or ameliorate, possibly is the best way to phrase it, the impact of Janus on collective bargaining across the board in New York State public sector. And one of the results of this is a group of professors sued the state, the governor, me. Like Marjorie, I too am a defendant. I was recently dismissed as a defendant, which reminds me of the great line from Doonesbury where Uncle Duke is told, "I've been acquitted. I like the acquitted life." And that's kind of how I feel about the whole thing. So we have basically the same sort of structures that Mary Beth and Marjorie were talking about. The case that dragged me into it for a brief period of time was one that tried to, in addition to other demands, do away with exclusive representation. To Marjorie's point about circuit courts, the Second Circuit has upheld exclusive representation multiple times. That's the circuit that New York State is cited in. And so all of those cases have gone in favor of preserving exclusive representation. And as Marjorie said, the Supreme Court has yet to grant certiorari. Hopefully they won't. It's not as if this is a court that has improved in the last few years since Janus. So what I want to talk about for the main body of my remarks is I want to talk a little bit about uniting. Thrilling, right? We're all excited. It's so good. You're going to love it. But I want to also talk about something that has come up in the uniting, in the exploration of unit definition, that sort of may be a little more interesting. So hang on, we're going to dive into the Constitution of New York State for a little bit. So first, a little bit about PERB. The New York State PERB, Public Employment Relations Board, has long been involved in deciding issues regarding higher education. We're not going to delve too much into individual cases about that, largely because we tend to have a peripheral role, except where we're doing something formative, such as unit definition or unit placement. We have, however, a role in avoiding strikes or preventing strikes, which are illegal in New York State, just as they are in Massachusetts. And we also have a role in preventing improper practices where possible. Now, the reason I don't want to spend too much time on that is because most of the cases that actually come to us are not really from the higher education branches. Oh, we get a few. FIT has brought a few to us that have been precedential and important. But on the whole, where we really see a lot of these principles coming out is in the school teacher cases, public schools in particular. So public sector collective bargaining rights became applicable to all public sector employees in the state of New York, including CUNY faculty and staff, on September 1st, 1967, which was the effective date of the Public Employees Fair Employment Act, which nobody ever calls it. It's generally called the Taylor Law. And from the very beginning, our exercise of jurisdiction to instantiate these rights happened relatively quickly. So I want to go back to an article from 1970. Our then director of public employment practices and representation, a man named Paul Klein, co-wrote an article with Janet Axelrod, a member of his staff. And the article addressed the rights conferred and how to enforce them. And as they wrote, the Public Employees Fair Employment Act in 1967, public employees in New York State were guaranteed a means for implementing their constitutionally conferred right to organize and bargain collectively through representatives of their own choosing. Their constitutionally guaranteed rights. Think about that for a second. Where did that come from? It's not in the Taylor Law. The Taylor Law has no constitutional dimension. So what Klein and Axelrod were referring to, they didn't really develop because, other than that one allusion in their article, because the Taylor Law tends to cover the field. As a general matter, it does cover all of the public sector employees' ability to unionize, to organize, and to collectively bargain. And yet, they weren't wrong to refer to the Constitution, to the state Constitution. Because in 1938, the New York State Constitutional Convention approved a new provision to the New York State Bill of Rights, Article 1, Section 17. That provision is titled, "Labor is not a commodity, hours and wages in public work, right to organize and bargain collectively." Okay. And there's a whole bunch of verbiage about public work being done and how it's going to be, how prevailing wages are going to be applied. But here's the really important part. Employees shall have the right to organize and to bargain collectively through representatives of their own choosing. Now, for decades, our intermediate appellate courts effectively glossed into non-existence that provision. Insofar as it applied to organization and collective bargaining. The prevailing wage part, yes, that got followed and applied. But in a case called Trustees of Columbia University, my law school alma mater, in the city of New York versus Herzog, the 1938 constitutional amendment, the First Department wrote, providing for collective bargaining accords recognition of a right to labor to organize and bargain collectively, which had already found expression in the Labor Relations Act and was not intended to invalidate existing legislation. In other words, the purpose of the constitutional amendment was not to change anything. Of course not. One clearly amends a constitution in order to preserve the status quo. A whole bunch of cases, Dominic v. Triborough Coach, Quill versus Eisenhower, held that the constitutional provision guaranteeing employees' right to organize and bargain collectively did not create a correlative obligation on the part of a university to bargain with the union because the State Labor Relations Act conferred no such duty. In other words, the state constitution, again, is 1952, did not mean anything. On that provision was basically dead in the water. And until 2019, that was in fact the state of the law in New York State. In 2019, we had a case that came out of farm laborers. And it was brought to the Appellate Division 3rd Department, the Intermediate Appellate Court cited in Albany, New York. It reversed and annulled all of these decisions in a case called Hernandez versus State of New York, finding that employees' constitutional right to organize and to bargain collectively through representatives of their own choosing is a fundamental right, and any statute impairing this right must withstand strict scrutiny. Now, Hernandez was brought by the New York State Civil Liberties Union representing a farm laborer, as I mentioned, and it brought this up until now dormant constitutional right to the fore with unknown potential to extend to workers throughout the state that as of now do not enjoy such rights. That's why I thought this was important to mention, because there is this sort of, depending on whether you're management or labor aligned or if you're a neutral, there's this sort of ticking time bomb from the management perspective, possibly, or this potential for change, if you are on the union side, that could lead to some very interesting developments in the next few years. Okay, so what I want to talk about from here is that Klein and Axelrod sort of forecast this concept but didn't develop it. Going back to the question of allowing employees to be able to bargain collectively in unions of their own choosing, one of the problems the Taylor Law initially had was there was no specific machinery for remedying breaches of these rights by public employers or employees. So in 1969, the law was amended, created the statute created what were called improper practices, and that's how we deal with alleged violations of the rights either of union or of management by the other side. And basically, we have a sort of quasi-judicial structure, which means that the board is the appellate court. We have administrative law judges who decide the cases of first instance. The cases come to us, and then they go to court for judicial review. Now, in higher education, I want to talk about two cases. And they're very similar, but very different because they're from different times. The first case was filed less than 3 months after the effective date of the Taylor Law. The Legislative Conference of the City of New York filed a petition seeking certification as the exclusive negotiating representative for all members of the instructional staff of the Board of Higher Education of the City of New York. The conference asserted there should be two separate negotiating unions, first for all those members of the temporary instructional staff serving in jobs which automatically lead to tenure upon completion of the applicable period of continuous employees, and all other members of the temporary instructional staff, the temporary staff, paid on an annual basis. And the Board of Education said, no, only one unit. All instructional personnel is appropriate for the purposes of collective negotiations. However, the Board of Higher Education further contended that lecturers working less than 6 hours should either be excluded from any unit or, if included, deemed ineligible to vote in any election that might be held. In his decision, Paul Klein, same gentleman who wrote that article with Janet Axelrod, found that it is insufficient justification to separate the annual lectures from the non-annual lectures. Similarly, he found there's nothing in the record to warrant the exclusion from the lectures unit of non-annual lecturers who work less than 6 hours. None of the parties had been able to ascertain just how many hours an average employee of this type or an average non-annual lecturer works, and therefore he basically was going on what little record he had on that point. On appeal, the PERB board affirmed the director's decision. The board stated that the employer is a municipal corporate. He gave a factual background, the board gave a factual background, and then wrote, there are 13 institutions subject to the jurisdiction of this employer, including 7 senior colleges, 6 community colleges. As of July 168, 2 senior colleges will be added. All of which is to say that the basic problem here was that the adjunct class, the non-annual class together, almost equaled the size of the permanent faculty. And that could have the effect of skewing collective bargaining in a way where those who were, and I'm going to read from the decision now, so don't blame me or praise me for this, but this is what the board wrote in 1968. The faculty rank status personnel are the heart of the university. It might be compromising to their independence and to the very stability of the university for non-tenured instructional personnel in numbers almost equal to that of faculty rank status personnel to be included in the unit of faculty rank status personnel. The board wrote, we believe that the differences between faculty rank status employees and non-annual lecturers whether they teach more or less than 6 hours a week, are of sufficient magnitude to preclude their being placed in the same negotiating unit. So in a way, there was also an assumption that non-annual lecturers and adjuncts in general, on the other hand, were likely to be full-time high school teachers working at the university at night, or businessmen, accountants, lawyers, or graduate students whose primary professional commitments are elsewhere. In other words, after all, guys, you're just a bunch of weekend warriors. We don't really need to care about you very much. It was not precisely our greatest moment. But the reprise in 2016 is a little different. Cayuga Community College, in 2016, we effectively revisited the issue. In that case, what we had was the college contended that adjunct faculty shared a strong community of interest with the full-time faculty and said, you know, Board of Higher Education, that decision from '69, you guys should really overturn that. It's just not right. And we looked at it, and I was deputy chair at the time, and the board had, the college accepted to our reliance on Board of Higher Education, or the ALJ's reliance on it, and we found that no, we're going to uphold Board of Higher Education, but for a different reason. In this case, both the faculty, and both the adjunct faculty and the tenured faculty, did not believe it was in their best interests to be joined together in one unit. Additionally, it was only the college that wanted them joined in one unit. Why? Well, because there was something like 3 times the number of adjuncts as there were permanent faculty, and that would genuinely skew the interests and would lead to the permanent faculty being essentially submerged into the adjunct category, and their interests would be possibly neglected or compromised. But beyond that, it would also make it more difficult for the adjuncts to effectively advocate for themselves through their union, because if they were put into one position, there would be basically friendly fire going on. How would they negotiate effectively? Under the duty of fair representation, of course, the union can prefer one side over the other as long as they're not doing it for invidious reasons. And the board decided, no, this time it makes a lot of sense, because there's no way that these two groups have the same interests. And that decision is the most recent one of significant importance, in which I believe that the board did the right thing in protecting the interests of both groups by keeping them separate. Now, we always look at the reasons for why they should allegedly have been put together. We looked at that, and it was basically non-specified. Oh, it would be much more administratively convenient. But that wasn't a sufficient grounds, because the administrative convenience was not detailed anywhere in the record. There was no such thing pointed out to us. So the reason I think this is important to bear in mind is that what PERB has done throughout is we have tried to get to pragmatic determinations of how uniting can work and create and protect the interests of the employees in a way that will not have detrimental impact on other employees. When management has a solid reason why they want to advocate for something, they can do that. And we will take that into consideration, and we have done over many years. But both in this case of Board of Higher Education in '69 and the 2016 County of Cayuga, I think you see the board doing its job correctly. I know we don't have much time left, and I think it might be good to leave room for questions. So I'm going to put down the microphone.
My suggestion is that we take questions all together and do about 10 minutes. We'll go into the break, but I'll take the microphone, and if anyone has questions, we'll take about 3 or 4 questions, and then the panel can respond.
There's one right behind you, Bill.
Hello, Richard Gomez, AFT New Jersey staff rep. Hi, Mary Beth. It's very nice to meet you. Okay, through email and voice. So, finally, thank you for all the great work that you folks do there at PERC. Without you folks, our unions would be in a lot of problems. So we greatly appreciate the time and effort that you folks guide us through. But anyway, I have two quick questions about the acts. The first one is about the Responsible Collective Negotiation Act. You mentioned that we call them free riders, the agency fee, because after all, they get to benefit from the contract without paying anything. But anyway, so you mentioned that they may be required to pay for grievances and arbitrations. I was under the impression it was just arbitrations, not grievances. That's my first question. The other quick question is about the WDEA. Have you had any challenges in the past of that? Because, you know, we've been getting some problems, but we've been able to mediate them. So.
Just take all the questions together at the same time. Any other questions? Any other questions right now?
My question is also for Mary Beth. My name is Janera Tice. I'm a traditional labor partner at Ackerman LLP in New York and a former senior field attorney with the National Labor Relations Board, Region 29 in Brooklyn. So I know that in your comments, you mentioned that there has been an acceptance of electronic signatures in card checks. And I was curious to find out if you have any additional background information as to why that move was taken, or whether there have been challenges to electronic signatures.
Any other questions?
For Mary Beth.
Okay. Sorry? Oh, both of Mary Beth.
Okay. All right, so the way the statute is written is it's the cost of arbitration. So we haven't had a case, so I speak as Mary Beth, who, you know, who am I? Nobody. I would think that you could charge the individual for the cost of legal representation through the grievance process, as well as what we mainly interpret it to be is the cost of the fine grievance arbitrators that we will provide to you from PERC to hear the case. Okay. All right, now the WDEA challenges. So I've only really had 6 filed, and they all came early. Quick unions saying, you know, asked to negotiate, really in South Jersey and boards of ed mainly. And when I picked up the phone, well, I sent my letter and then I picked up the phone and called the attorney. They had no idea that it had even been passed. I know. Yeah. And once I told them, you know, you have to go to binding arbitration, and here's the name of your arbitrator, because it's, you know, they backed off. And so they've all settled. And the state led the way with the contract, and they did negotiate with CWA regarding those. So there is language out there that people can follow, you know, and I found that once they settled it, it's kind of gotten everybody else in. That's not to say that we don't have I mean, I think we currently have a Rutgers case pending where there's a individual dean who's not letting higher ed people are going to listserv, or I don't know, it's some sort of internal thing. So that's pending with us, that they were saying that union business can't be posted there. But,
Oh, I see.
and the union came back saying, but people can post their vacation pictures and their poetry readings. Why can't? So we'll see. Right, we'll see where that goes. Okay. The electronic signatures, I don't know. I'm not in our unfair practices group. I don't know. I do know that we reached out to Mike Sellers from Washington for help because we are dealing with a very old computer system at PERC. We're hoping to ramp it up. I just think maybe while they were, it probably stemmed from the unions lobbying the legislature that, you know what, we don't need to actually sign cards anymore. Email's secure, and we should get on board with that. That's what I presume. We're independent, you know, neutral agency. We don't get involved while the statute's being written, so I don't have any more background info.
We got a lot of questions about that, and we've gotten pushback from some of our clientele about that. We don't do e-signatures because our statutes, the way they're written for card check, make it clear you're comparing an actual signature. But I do know that California does e-signatures, and when we've had our folks come to us asking, we've actually said, how does it work? We're curious how this would work. We're trying to wrap our head around how that would work. I do know that some of the impetus for it was during, of course, the pandemic. How do I get a card? And the way we short-circuited, given our statute, we said, we accept pictures of a written card. And they're e-filed anyway. We don't have a true e-filing system. We will someday if this project ever finishes. But they file by email, and so they've converted it to a digital document. So that's how we've kind of bridged that. But I do know that there are some jurisdictions, California, I think it's the CalPERB, so you might reach out there. And I do know that I think there are some in Canada. I think the BC Labor Board may also do that as well.
We've gone to accepting email. The board has been doing it for several years as a pilot program, which means that we have no real computer system, so we're basically taking it via email. And we are by rule, we have now by rule allowed for e-filing in front of the PERB board and ALJs in our farm labor jurisdiction, which was granted to us as the survivors of the 2019 case involving farm laborers. And I think that we're in the process of trying to update ourselves from cuneiform style tablets and styluses. Hopefully we'll get there before I die of old age. Thanks for.
Just really quick to add, we were already accepting pictures of cards, so I don't know why electronic signatures were added, but they have been. Pictures.
Any additional questions that may have spawned? I think I want to thank Marjorie, Mary Beth, and John and for adapting as that went along. I think we could have all talked a lot longer. I think the other thing I would just kind of close with in the unity sector, or the higher ed sector, is uniting is, I think, probably more of a continued issue in that sector than we see in any others, just because of the breadth, like I talked about. Are you a medical system, or are you an educational system? And now you have the student employees and those issues, and higher ed have employees. The University of Washington has employees working in Arizona at the primate center. They're covered by state law, so they can bargain in Washington's law, and the right to work laws of the tribe where the primate center, the reservation where the primate center is located, doesn't contravene that. So I think in the higher ed sector, you see a confluence of all laws in a way that you don't see with other groups. So thank you for the time today.